Welcome to Wills and Probates, a bonanza of information for genealogists. My name is Stephanie Asberry, and I'm the supervisor of the Genealogy Division at the Indiana State Library. During this webinar, I'm going to be talking about the exciting topic of wills and probates and how they can help you with your genealogy research. So what is a will record? As most of us know, a will is a legal document in which a person specifies the disposition of his or her property after death. After a person's death, that person is referred to as the decedent or deceased. In this webinar, when speaking of a decedent that left a will, I will occasionally refer to that person as the testator. Unless someone died intestate, which means without a will, they would have had either an attested will, a holographic will, or a nuncupative will. Attested wills are the most common, and they are usually done in advance by the testator, or as mentioned, the one who wrote the will. They also involve witnesses who will attest later that the decedent made the will freely and was of sound mind. Holographic wills are written in the deceased's handwriting and are not witnessed. They are usually found among the deceased important papers. If there is any other handwriting from anyone else on it, it is considered invalid. A holographic will is not valid in all states. A nuncupative will is oftentimes referred to as a deathbed will. It is orally presented and is not recorded and not written or signed while the decedent was alive. Witnesses later make depositions to its provisions, and if approved by the court, those wishes are carried out. A nuncupative will is also not valid in all states. This example concerns a nuncupative will and shows evidence from family or friends about what a soldier had stated verbally concerning his wishes or had written down in his will, which could not be found. Typically, evidence concerning nuncupative wills consists of correspondence and official forms. So, what about probate records? The main function of a probate record is the settlement or division of property after a person's death. Not all probates involve a will. Some people die without a will, and the state divides the property. The use of the term probate can also refer to all matters of the probate court or the probate process. In some states and in some situations, the term probate refers to estate records, which can be the same thing. The term probate comes from the Latin term which means to prove. Part of this involves court processes and witnesses to authenticate it. Probate records can establish relationships. In the most basic situation, heirs are named in the will. For some individuals, even though a name is listed, there may not be a relationship stated. According to Donald Wilson, in an article in the Smith County Historical and Genealogical Society newsletter, sometimes a probate may help determine the birth order and ages of children, and can prove the remarriage of the widow and the name of the new husband. Sometimes actual names of children and daughters' husbands are not mentioned in the will. There may be a guardian's accounts that show what happened to minor children and may prove birth dates, marriages, and names of other kin. In terms of property, land owned is usually mentioned in the probate process. There may be several tracts or pieces of land being talked about. Sometimes it may appear that the deceased owned property that may be miles away. However, that may not actually be true. It may be that the deceased held a note for a mortgage. The personal inventory of the deceased can give a clue as to the occupation. Type of furniture, the presence or absence of books, farm equipment, and livestock can tell you a lot about the social status and the lifestyle that your ancestor may have enjoyed. The two basic terms here that refer to the probate process are testate, where your ancestor died with a will, and intestate, where there was no will. The probate process differs in either case. The probate process is regulated by state law. In Indiana, it would be included in the Indiana Code, which is available at the Indiana State Library. The principles of law that apply to probates developed from English common law. It is based on a history of judges' decisions rather than relying on lawmakers. Common law developed a fairness in the courts with regard to individual rights and the protection of private property. The probate process, which will be described here briefly, was a court process. To begin the probate process, a petition was filed with the court. The petition to the court involves witnesses appearing and attesting that they witnessed the testator signing the will on a specific date. The date is very important because it is necessary to have the most recent will. Sometimes sworn affidavits are presented to the court in lieu of a public appearance. When researching, keep in mind that not only can you find relatives named within the will itself, but relatives can also serve as witnesses and bondsmen. It is also possible for bondsmen to be heirs. When the petition is accepted by the court, then letters testamentary are issued to the executor or executrix, giving them legal control to dispose of the estate. In case of someone who died without a will, then letters of administration are issued by the court. So what about an executor or executrix? This is a person that was appointed by the testator to execute the provisions of a will. When there is no will, an administrator, as mentioned, is appointed by the court. An administrator is also appointed if the executor resigned. An executor must be approved by the court and might be refused for various reasons, such as being of unsound mind, a married woman in her early years, or having been convicted of a crime. An administrator is usually from the family. If the family does not want the responsibility, then a creditor or public administrator may be appointed. It's the job of appraisers, which are usually appointed by the court, to determine if the value of the estate from papers that the executor has compiled. The executor will publish public notices for an estate sale. These notices can also instruct anyone that owes money to the estate or has claims against it to present them to the executor or executrix within a specified period of time. The time frame can vary based on the size of the estate. It is important to remember that where to find these papers can vary depending on the jurisdiction and time period during which you are researching. Michael Neal, in his introduction to probate, suggests that most of the early records were bound volumes of orders and not the papers themselves. Sometimes there are separate books with copies of the will, estate inventories, bonds, and other records. At other times, there are loose papers that appear in probate packets. Once the estate is inventoried by the appraiser, it is presented to the court. In a will that is simple, assets can be distributed to the heirs. The assets of an estate sometimes need to be liquidated to pay debts. This process involves an estate sale. Records of an estate sale will list assets sold and the amount obtained. After debts are paid, any remaining money will then be distributed to the heirs. Distribution of the estate can be based on the common law rights of dower and courtesy. A simple definition of a dower is a wife's interest in her husband's estate, and a husband's interest in his wife's estate is called courtesy. Generally, a wife's dower is the portion of her husband's real property allowed to her for life. In most cases, it was 1/3. Sometimes a wife accepted other property left to her in her husband's will. A dower usually applied to each parcel of land in which the husband had an inheritable interest at any time during the marriage. Different states had different laws with regard to a woman's right to hold property. So it's important to research the land and property laws in the state and time period where you're searching. By doing so, you'll have clues as to what kind of documents to search for. A wife's dower interest in her husband's land while they are both still living was called inchoate dower. When her husband died, it became dower consummate and entitled her to 1/3 of the share and profits from all the land, no matter who owned it. A public official, such as a sheriff or judge, could lay out boundaries for the 1/3 share of the estate. The wife's portion then became known as vested or assigned dower. If you don't find the signature of the wife on the deed, it doesn't necessarily mean anything in particular. It may mean that she either died before her husband or she may have stayed home with the kids when the will was made. In each case, it's necessary to determine the time and place that the deed was signed to make out whether or not you can figure out what happened to the wife or where she was. Until the enactment of Married Women Emancipation Acts in the middle of the late 19th century, a married woman was subject to coverture or femme covert. A woman not legally married or separated from her husband was not under the disability of coverture and was called a femme sole. She was described as such in wills and deeds. Coverture meant that a husband could act for the wife in any legal proceeding, including selling her own land. He also controlled any personal property, such as clothes or jewelry. Generally, he couldn't sell more than his lifetime interest in her land because his rights did not extend any further. However, this wasn't true in all states. In England, there was the use of separate estates, which allowed a wife, with her husband's consent, to manage as her own any property specifically set aside for her support. Primogeniture meant that the eldest son inherited all of the estate. This was primarily in colonial times. If the eldest son wasn't listed in the will at all, it wasn't really necessary, as the law stated that all property automatically came to him. So sometimes the eldest son even received a double share of the otherwise equally divided estate. A daughter's share of the estate was often left to her husband. Generally, this happened because a woman was not allowed to own real property or because it was felt that she couldn't manage the affairs of the bequest. Sometimes, because a father may have settled on a dowry on his daughter when she married, the father's bequest may be a smaller one than to other unmarried sisters. It's also possible that a will may leave an unmarried daughter a larger amount than her sisters in order to make them equal in their overall shares of the estate. So watch for, in a will, how the names of children are listed. Sometimes a comma will be left out. For instance, Mary Elizabeth may appear as one person, but in fact, she might actually be two people, Mary and Elizabeth. You may want to use marriage or other records to prove the existence of two people. Sometimes the testator made arrangements for a son to be an apprentice or indentured servant. So you might want to look at court records that may have formalized the arrangement. This would be in a guardian situation, since the person became responsible by law for the child. Sometimes the court will order the child be found after the child has been given an equal portion of the estate. The absence of a child's name can indicate that the child is deceased or may have moved elsewhere. The executor or executrix files notice with the court that all accounts due have been collected, and all debts have been paid, and that the court is ready to settle and divide the estate. The final settlement document is prepared by the executor or executrix based on the terms of the will and the final assets of the estate. Real and personal property is distributed. A fee is paid to the executor or executrix, and trustees are appointed by the court if there's a trust or trust fund. Some other things you may want to consider are, was there the will an original or a recorded copy? And there are several clues you can look for to help you make that decision as to whether or not it was original or not. For instance, does it bear the testator's signature or mark? Does the text flow smoothly from the bottom of the one page to the top of the next? And does the handwriting match throughout? If infants or minors are mentioned, it's possible that the estate wasn't settled until the last child reached adulthood. So it's suggested that court records be checked for at least 2 decades following a person's death. Infants are historically referred to as a person who was a minor. Tender age meant a person under 14. You can also look to see if education was willed to the children. Outside the Northeast, mid to older teens were not likely to be schooled unless the family was wealthy or elite. Sometimes property is conveyed in advance. You can also look to see if a grandchild received a special share. This happened if, a lot of times, if the son was deceased or the daughter was unmarried. Are relationships stated to certain people? Sons and daughters-in-law could be stepchildren. Cousins may be in any relationship past the first degree, and a nephew can often be referred to as a grandchild even. Some things that may also be considered are slaves manumitted. According to Elizabeth Shown Mills, significance can depend upon age and color of those freed, religious affiliation of testator, or whether testator was a living wife or descendants. As you know, there are often times when there is no probate. So what happens then? Sometimes an ancestor didn't have enough of an estate to probate. The amount that the estate had to be under varied from state to state. Sometimes there was not enough money to even bury a relative. So in those cases, there was nothing in that estate to probate. Sometimes your ancestor avoided probate by selling all real property before his death. This would actually have only minor personal items in the estate. Tracing of property may be done using deed records in these cases, even though relationships may not always be stated. Sometimes a probate was delayed due to the wife's share of property never being surveyed or not partitioned off. The wife and children could become aggregate owners of a husband's property at his death. In this case, you would need to check records other than probate or estate to see if there were any other court records pertaining to the estate. This is especially true if there were minor children that needed a guardian or trustee to look out for their interests. In terms of guardianship, a male relative in the early years was appointed to look after the interests of minor children. Mothers during this time period were not trusted to have the responsibilities of guardianship. It could be that family folklore is just plain wrong. Sometimes, even though a family member may tell you otherwise, it's possible that an ancestor did not have enough to probate. To help confirm this, you would want to look at other records that could show that the ancestor never had enough of an estate to warrant a probate. Post-death land records transferred property without the need of a probate, which could have been to a family member or someone outside the family. Post-death land records would not appear under the decedent's name, so search for names of children, including married daughters, may be necessary to find the land. You would want to become familiar with laws that deal with probate procedures in the various states you're researching, since those laws varied from state to state. You can also check for the last survivor. In other words, if you can't find an estate for the husband, who may have died first, look for the estate of a wife after she dies. A woman is more likely to have a probate file if she survives her husband. You should be sure to check in the area or county where the bulk of the property was located. A check for records in 2 counties may be necessary if your ancestor lived near a county line. Make sure you look for records in the time period where your ancestor actually died and perhaps up to 20 years later. If you cannot find a probate record on a particular ancestor, look for a relative. So just how do you access wills and probates at the Indiana State Library and other collections? There are wills and probates in early years that can be found in bound volumes in the courthouses. It's possible they're intermingled with other records. There can also be loose papers that are part of a probate packet, as I mentioned earlier. Remember to check beyond the date that the estate was closed. The Indiana State Library Genealogy Collection has indexes and abstracts of wills and probates for Indiana, as well as some other states, in the book collection in the Genealogy Reading Room. There are also copies of wills and probates for many Indiana counties available in the microfilm collection on the second floor. As a Family Search Affiliate library, we also have access to county records such as wills and probates that we may not have on microfilm. For specific information on holdings, you may wish to check our online catalog under the name of the county. You can also check under Collections and Services from the State Library's homepage, and then Collections by County. This provides a link to all of the 92 counties in Indiana, where you can find a listing of the many holdings for that county, including microfilm. You can also check the Family Search website at familysearch.org for wills and probates for a specific county. On that website, check the catalog under the search feature. You can do a place search with the name of the state and the county. As mentioned earlier, since the Indiana State Library is an affiliate library, many of the records that have been digitized are available to view here. The Indiana State Archives also has a collection of court records and wills. You'll want to check their online database to see if that can be of any assistance to you. In Indiana, early courts were established before statehood. As you can see, various courts had jurisdiction over probates during different time periods. Wills were to be recorded in separate ledgers during a certain time period, which was 1807 to 1816. After statehood, the circuit court had probate jurisdiction. This would have been from about 1817 to 1830, but separate ledgers were rarely kept, especially prior to 1825, and most courts mixed probate proceedings with other actions. While many courts began keeping separate probate ledgers in 1825, the primary ledger was called a record of last wills and testamentary. Many wills were recorded in this ledger, and upon rebinding were called will records. Not all wills, however, were recorded in this ledger. In 1829, a separate probate court was legislated, and with it, separate probate order books. This court was replaced in 1853 with the Court of Common Pleas. It was abolished in 1873, and its jurisdiction was then transferred to the Circuit Court. Many order books continued sequential numbering. For most counties, the court with probate jurisdiction has been the Circuit Court. Certain exceptions exist. Superior courts in Lake, LaPorte, and Porter counties, for example, have had probate jurisdiction since 1899, and separate probate courts were created in Marion, Vanderburgh, and St. Joseph counties. Now I'm just going to run through some examples of wills and probates. This is an example from our microfilm from Book D of the probate order book for Franklin County, Indiana. It's an order that sets up James L. Miller with letters of administration for the estate of Andrew J. Miller. The genealogy collection has many types of records pertaining to probates. These are included in probate order books like the example shown, or in complete probate records, circuit court records, and the various courts that were already described for Indiana. Sometimes there is probate information as part of a partition record. This is the dividing of property that may be found in both probate and land records. This transcript is an example from Brown County for the estate of Robert Bush. It is a petition to sell real estate dated September 18, 1869. It's an intestate case where the property had to be sold to pay for debts on the estate. The wife, Anna, died in Missouri before Robert. This probate also makes arrangements for the care of minor children and many other family members. The next transcript is another example from Brown County for George Percifield concerning an estate worth $500 or less, dated 1897. The widow is Rachel Percifield, and the names of the appraisers are also noted. There's a petition to sell real estate. There were also letters of guardianship described, as well as mention of a partition suit, which is defined as a lawsuit brought on by dissenting heirs to force the division of real estate so that each could have personal possession of his inheritance. No details of the partition suit are provided here. It is possible, however, that a complete probate record may provide further details. This is an example from a book entitled Abstract of Wills, Madison County, Indiana, Will Record I, June 1879 through November 1892 in the Circuit Court. This book of abstracts was compiled by the Daughters of the American Revolution. It shows an example of the transcription of information concerning the will of an Elizabeth Heritage and provides information on her sons, daughters, and family. Here is an example from the multi-volume set of books on the first wills of Marion County, Indiana, compiled by the Caroline Scott Harrison chapter of the DAR. This will is noteworthy in that it gives detailed instructions from a John Black to his wife with regard to his property, which seem to be somewhat extensive. He mentions that he's a resident of Hendricks County, but most of the property was in Marion County. Boone County is also mentioned. This is a sample of a page from the book specifically on guardianships from Washington County, Indiana. This shows that our collection on books for wills and probates isn't restricted to Indiana, but includes many other states. This is a sample taken from Westmoreland County, Virginia. It includes estates in colonial Virginia from 1691 to 1699. The sample shown here indicates estate worth in terms of pounds of tobacco, which at the time was legal tender in that area. So now I'm going to touch on some websites that pertain to wills and probates. In colonial Maryland, the probate process was controlled by the prerogative court, which was an outgrowth from England and English common law. In 1692, the deputy commissary was appointed for each county. He was responsible for recording the will or account in his own books and to also send documents to the prerogative court where they would be recorded again. Testamentary proceedings would also be set up. After 1776, the prerogative court was abolished. Later, a chief clerk and register of wills was set up in each county to do most of the work of the court. The URL for information on Maryland probates is shown here. In Connecticut, prior to the creation of Connecticut probate courts in 1698, wills were proved and recorded in other colonial jurisdictions. In early years, it was provided that wills and probates were to be administered in the town where the deceased resided. These were plantation records or town records. Early will records for Virginia were part of circuit court records. Clayton Torrance indexed early wills from Virginia in his book published in 1931, which covers the years 1632 to 1800. This has been incorporated in an index to wills and administrations, a database located on the Library of Virginia's website and administered by the Library of Virginia. The database, in addition to including entries by Torrance, also includes documents not located in county records, but rather from counties in Virginia where official records do not exist. Each database record includes the name of the deceased, the county or city, the type of document, the date the document was recorded, and references to the source where the document can be found. For most records, the Library of Virginia microfilm reel number is also included. This is the search page for the Wills and Administrations database on the Library of Virginia website. Also maintained by the Library of Virginia is a legislative petitions database. This database provides a calendar of legislative petitions submitted to the General Assembly between 1776 and 1865. The database lists the name of the petitioner, locality, date of presentation, description, reel number, box number, and folder number. In addition, each petition has been assigned one or more topics for indexing purposes. There are 4 ways to search the database: by petitioner, by locality, by description, or by topic. The petitions are on microfilm in the West Reading Room and available through interlibrary loan at the Library of Virginia. Frequently, the petitions contain supplementary support documents useful in research, including maps, wills, naturalizations, deeds, resolutions, affidavits, judgments, and other items. There are also various wills and probate collections on Ancestry. Just so you can see what some of those pages may look like, I'm going to run through a few of them. They will differ depending on the collection. Cindy's list of genealogical sites on the internet also has links to some helpful resources on wills and probates. To take another look at a different state archives, the Missouri State Archives has a database for Missouri's judicial records. Researchers often overlook the immense value of circuit court files. These files can be challenging to researchers, but they offer a clear snapshot of daily life in a time period. In an era where reputation was the basis for social standing, the only recourse available to those who had been wronged was through litigation. The opportunities for research into social history, commerce, freedom, race, gender, architecture, and other topics are tremendous in circuit court records. Missouri circuit courts heard cases dealing with everything from fur trade to the Civil War, steamboats to McCormick reapers, and agriculture to urbanization. For many years, the Missouri State Archives has worked with local court officials to help preserve, index, and microfilm their records. Now, through the Missouri Digital Heritage Initiative, digitized collections of court files are available to researchers online. Records are available by county, court, and year, and are searchable by name and keyword. The internet does provide specific surname results for will records. An example is shown here for the surname Meade in England. The screen shows the name and how it appears in the various locations throughout England. This is an example of Robert Meade of Great Easton in 1560, which was located from the Essex search. This shows a glossary of unusual words found in wills from England in the 16th and 17th centuries. It can be located in Google through a search for the terms Glossary of Unusual Words in Wills. There's also a website for all known wills of the Mayflower passengers. Each of the names can be searched and the images displayed. The example that is shown here as part of this website is for a William Mullins and is the only surviving will for an individual who died that first winter at Plymouth. So as we wrap this up, let's consider the question of why are wills and probates so important? According to Thomas Jones, noted professional genealogist and co-editor of the National Genealogical Society Quarterly, wills and probates show direct evidence in that they specify direct relationships among several people. Indirect evidence information that is important to a genealogical question needs to be combined with other information before an answer can be developed. With negative evidence, the absence of a person from a record can be used to rule out a relationship or other genealogical fact. Negative evidence in an estate record is difficult because many times offspring of the deceased aren't named. The fleshing out of wills and probates can provide interesting details on your ancestor's life, such as the type and kind of items owned by your ancestors. I hope you learned a few interesting facts today, and best of luck in finding your ancestors